So we'll start letting people in. Okay, Saloni?
Perfect, thank you. Hello, everybody. Welcome to our session today. We're just going to give it a few minutes till people join, get settled.
Recording in progress.
Hi, everyone. Welcome. We're just waiting for people to join in. Just give us a few minutes. I can see people still come in, so we'll just give it a few more minutes. Thank you all for joining. Well, there's a steady stream of people coming in, so maybe I'll give it one more minute. All right. Thank you, everyone, for joining. We have a packed webinar today. We're going to be talking about worker proposals in context with the upcoming ILC in Geneva in June. Interpretation is available for this webinar. If you are on your laptop, you can click the globe icon at the bottom of your screen and select the language you want to hear this in. If you're on your phone, I think it's 3 dots. So please make sure you take a minute to do that. This is a recorded webinar, and anyone who's registered will receive this recording from us in the next few days, along with any material that speakers may want to share with you. The chat function is open, so please feel free to introduce yourself, leave any questions. We want to, hear from all of you. Unfortunately, we can't have everyone speaking, though it would be great, but please feel free to use the chat. And with that, perhaps we can jump into it, although I see people still joining. Welcome, everyone. And yeah, let's get started. Perhaps we do have a full 2 hours. I wanted to start the webinar by mentioning that it is 12 years since the Rana Plaza fire today, where a number of garment workers in Bangladesh, primarily women, lost their lives, and we got to hear of exploitative labor conditions in the garment supply chain. Some conditions have improved, still a work in progress. Today, we're going to be talking still about precarious conditions in which workers continue to engage with work, although the context is different, and we're going to be speaking of platform work today. But there are still links to informal employment, which we hope to draw out and hope to learn from our past experiences organizing workers in informal economies and advocating for their rights. In the context of this webinar, we are speaking to the International Labour Conference, which is happening in June. It is an important moment. Several years of fight for platform workers by platform workers is going to come to some sort of culmination in June. It has not been an easy fight for many reasons. It is a very general state of neoliberal governments increasingly shrinking space for workers to collectively bargain. And also the transnational nature of platforms means the fight is harder. But we will still be fighting, and we will be fighting for a strong instrument. Today, we're collecting workers' reactions, proposals to the ILO Blue Report, which will be the report that is debated in Geneva. So I'm assuming a lot of you are familiar with what the Blue Report is, but just a little bit of context. This was published in March, and this is the draft language of the convention, which will be voted upon, deliberated, argued in June, and will become the final instrument for standard setting in the platform economy. So today we want to do 2 things. We want to hear from several sectors of workers, find out what their common issues are with the proposed convention and how we want to improve this. In doing so, we need to be mindful of a few things. we need to keep governments in mind and be very strategic in terms of what amendments and proposals we're pushing forward, because the convention needs to be ratified. It's only useful for workers if it is a ratified convention by their countries. So we need to be strategic with respect to that. Also, we need to be mindful of differences in terms of gender-based experiences of workers. Um, and we need to be pushing for a more inclusive instrument for all platform workers. So for the purpose of this webinar, in the background, as our workers speak, we will be keeping note of these proposed amendments as they come in. Like I said, participants, please feel free to use the Q&A section and add in, or the chat section, sorry, and add in anything you want to also put forward in terms of proposal and amendments. And what we want to come out of this is sort of a longer list, a landscape of worker amendments and proposals for the convention. And over the next month, we will be working on this, prioritizing, putting specific language onto the proposals. But I will leave it to Monica, who's here with us today, to speak to that perhaps. So let me get right to it. We have 4 speakers in the first sort of round of speaking. They are from different sectors of work. And they will be speaking to their own region. They are from different regions also and different sectors of work, and proposing amendments to the ILO Blue Report. So Christine, I'm going to call on you first. Christine is a home-based platform worker, a member of the BPO Industry Employees Network in the Philippines, and also a part of the Global Platform Worker Solidarity Project. Christine, after you, we'll have Angelica from Chile, who's also part of the Latin American Women Platform Workers Network. Then we have Mercy, who's the executive director at the Oversight Lab. And finally, Nicole, it's very early for you, so thank you for joining. And Nicole is the president of the Rideshare Drivers United and also part of the International Alliance of App-Based Transport Workers, IAATW. So Christine, over to you.
Hi, thank you. Good day to everyone from whichever time zone you guys are. So yeah, I'm from the BPO Industry Employees Network. We organize BPO workers primarily, but because there's no other organizations that are in charge of organizing outsourced workers, in which, well, the Philippines is a hotspot for outsourcing due to its cheap labor. So we are organizing home-based platform workers, or also considered as data workers. So we have data annotators, we have labelers, content moderators, and all sorts of virtual assistants. W Sorry, should we share the PowerPoint now?
I will.
Okay, thank you. And I guess while we're waiting, I would also want to give you guys an idea of what this alliance or solidarity project is. So aside from just representing my organization as an organization that's organizing outsourced workers from the Philippines, we're also part of a bigger project in which was originally or initially was formed last year, June 2025, because there was a convening, as we all know, in the ILC for the labor standards, or setting the standards basically for platform workers. During that time, a lot of organizers invited us workers from different parts of the world to basically create a list of demands, to strategize, meet, and basically try to rewrite the rules of the digital economy, in which we all know multinational corporations are doing their best to exploit the loopholes that are, well, there's no regulations for platform workers. There are labor standards, but because the onset of digital economy, there are some aspects of the digital world that is not regulated, and of course, we are being exploited through this manner. And so aside from that is what I'm going to be representing right now. Of course, we have other care workers here. So I'll also speak briefly for care workers, because well, there has been some discussions for data workers such as myself and discussions for care workers. So I'll try to give a brief summary of, or yeah, a brief summary of the demands of both data workers and care workers. But of course, if other care workers would like to give their comments, feel free to do that in the chat box. So I'll go ahead and start. So this throughout the year that we have been meeting online, and since also last year, June 2025, uh, our alliance or global platform worker solidarity project, through the help of a lot of organizers such as Anusha, other platform workers, we have composed these list of demands. So next slide, please. So, as I said earlier, I'm a data worker. We organize independent contractors, employers of records, partners, which are basically just terms that employers or principals use in order to circumvent the existing labor standards, labor rights that the workers should be entitled to. So what are these workers? So they're data labelers, annotators, content moderators, um, virtual assistants, or any type of work in which um, a multinational corporation that could be something that we're all familiar with, such as Meta, um, Amazon, and all of these mega corporations would hire or outsource work from third world countries such as the Philippines. And then for care workers, I try to uh, I try to represent. I'm going to try to represent this. So this is basically for people that are being contracted for childcare work or domestic work, but through platforms as well. Okay, next slide. So these are, I'm going to try to list out the demands as briefly as possible for data workers throughout the previous meetings that we've had. Sorry, there's a bit of an echo there. Anyway, so first, we've listed a lot of demands, of course, but we want to make it concise. We want to ensure that we'll only submit the priorities that should be part of the amendments or whatever discussion will happen in the upcoming convening in June 2026. So for data workers, there's 9 items, and then there are similarities with care work and some special demands for data and special demands for care work. So I'll go ahead and proceed with data workers first. First, we want to address the employment misclassifications. A lot of issues arise from misclassifications, such as the fact that a lot of workers don't have social security or benefits, or are not living or are not receiving minimum wages, which has already been set by the country or um, whichever is the setting of the platform worker. So the problem is that in the Blue Report, we all know that what they did is that they just want to leave the um, classification of employment according to the national laws. So it's not explicitly implying uh, the Blue Report is not explicitly implying the employment status of platform workers, which is, as I said, is the primary reason why we're all trying to convene here, why we're all trying to address the issue. So that's the number one priority for data workers. And then, of course, we also want to ensure the freedom of association and expression, because for um, for a lot of us platform workers, for a lot of us that are trying to raise the standards for labor, we receive retaliations from the employers or the principals or our those that are in charge of our employment status. So we want to ensure that regardless of whatever grievance mechanism we want to address, or whatever issues we want to address, they will not be met with any retaliation. Number three, we want to ensure that the employers will be responsible for cost-related expenses. So, of course, we all know that it's not just for data workers. There's also the riders or delivery centered platform workers, in which they have to shoulder the cost of their equipments. So the principals, the employers should be in charge of this and not us workers. And then we also want to raise concerns regarding mental health support, because um, for platform workers in the data sector, the work is very extensive, and there's no such thing as occupational safety and health discussions, especially for psychosocial harm or hazard, because, well, we all know that previously, for the last decade, psychosocial risk or harm or hazard are not actually have not yet been discussed, have not been integrated into most of the country's labor laws. So we want to ensure that this time this will be part of the new labor standards. Then we want contract transparency, because we want to ensure that whatever job description will be provided will be the only kind of job that we will work for, and not beyond what was agreed upon by the employee and the employer. Next slide, please. So a big issue for us data workers as well is the algorithmic management. We want to ensure that the algorithmic management, or the coding that will be used for managing the employees, will be transparent. We, as employees, should have access, should have an idea how this works, and there should be approval from us employees first, or the government, before any changes to the algorithmic management happens, because we want to ensure that the abuses, the loopholes are addressed and will not be exploited by the employers. Then we want to have worker control over personal and work-related data, because a lot of the principals or the employers or the companies that we work for harvest data, not just to survey, not just for surveillance, but also in order to sell our data to whatever third party company there is that will benefit from the data they have collected. So we want to ensure that we have control over the data that is being collected, and we have access to whatever data is going to be collected from us. And then this is a particular concern that us data workers want to ensure, which is something that I believe is not um, an issue for other types of platform workers, the cross-border labor enforcement and cooperation. So this basically means that the regardless of the country that the employees are based on, and regardless of the country of the corporations are based, or their headquarters are registered on, there should be joint agreement, there should be cooperation between the labor laws of the employee and the labor laws of the principal. So this has already this has historically been accomplished previously. So why can't the ILO also set it as a standard internationally moving forward? So also, we want to have clear liability and joint employment arrangements, because for us here in the Philippines, outsourcing, and for other countries as well, outsourcing is a very extensive issue, because a lot of the employers would subcontract the work to other companies, and then the other company would subcontract the work to other company, in which the uh, global service value chain will become very will be unclear for us, and we will not have any access to the SLA agreements or the service level agreements between the companies. So we want to ensure that there will be transparency for this as well. Okay, so next slide. So I'm going to proceed with the similarities of the demands for data and care workers. So, first of all, the labor standards. So, we want to ensure that the labor standards that the ILC will enforce not only meet the existing labor laws uh, that are enforced or implemented in the country in which whatever is which whatever whichever country the employee is based on, but must also go beyond those existing laws, because we all know that the digital economy is new. There's a lot of loopholes. There are a lot of issues that are not being addressed because this is new. So we want to make sure that whatever law they pass is beyond the existing laws, because there are some countries in which the labor laws are not enough, are not sufficient for workers to have decent um, decent working conditions. And then for labor rights, we also want to data workers and care workers want to ensure that the full rights and benefits should be granted um, regardless of whatever arrangement the employee and the employer set for each other. So it's regardless if you are considered as an informal employee or an independent contractor or a migrant worker. So this is a big issue for us because there are a lot of data workers and care workers that are not legally bound by the national laws because of whatever discrimination that is manifested through the policies that they have. So we want to ensure that regardless of the legal status of the worker, they should be they should be guaranteed basic labor rights. So next slide. And then of course, we want fair wages. So the pay should reflect actual work done and should be clear in the contract, because for data and care work, a lot of the employers, the principals, the clients would make contracts with us employees, as workers, but once we're already done with the work that was agreed upon, the principals or the clients, the companies would ask us to do more than what is written in the job description, which leaves us vulnerable to um, overtime work, for working more than what is agreed upon, working more than the wages that we have or what was uh, under the contract. So we want to ensure that um, the companies, the employers will be held accountable for these kinds of exploitation. And then for the algorithmic management, as I said earlier, there should be democratic governance of the algorithmic management. So this means that the information, the um, programming, the coding that will be used to enforce auditing or managing of the workers should be transparent and should be up for approval by the workers who will be managed by this kind of program. And then, of course, we also want to ensure rest and safety. So rest being we should be entitled for paid leaves, because for care work and data workers, there's no such thing as paid leaves, which is also stemming from the fact that a lot of us are not considered as formal employees. So we want to ensure as well that for data workers that are exposed to egregious or violent or uh, distressing content are provided with enough mental health support or comprehensive mental health support. So there should also be labor inspections, especially for care work, because we all know that for care work, the employees or the workers will be contracted through the platforms, and then they will be asked to go to the houses or the workplaces that are uh, that in which they were contracted with. So we want to ensure that those places are safe for the workers, because there's a lot of harassment, assaults that are happening, and it's very difficult, of course, for women especially to address these kinds of issues. So we want to at least minimize um, these kinds of exposure or vulnerabilities. And then the pay to work model, which basically just means that the employers should be responsible for the cost related expenses of the workers when working for them. Next slide, please.
Christine, can I ask you to sort of close off in the next half minute, please?
Yes.
Thank you.
So for care workers, this is the particular need that we want to ensure for care workers in the Blue Report. So not only should the government have full access to the algorithmic management and decision making, the government should also have access to human management and decision making, because a lot of discrimination is happening for care workers. So next slide. And that's it. That's all for our side.
Thank you so much. You've brought in very relevant aspects of this, particularly, the reliance of the instrument on national laws, and often national laws are the ones that discriminate against workers. So thank you for bringing that very clearly. Let's move to Chile, and Angelica, you're here. Can I ask you to come in with your proposals and amendments, please?
Buenos días a todas y a todos. A ver, primero agradecer este espacio porque la verdad es que las realidades de los países son tan disímiles, pero a la vez tan unificadas. Yo escuché el reporte anterior y la verdad es que me siento completamente identificada con la realidad chilena. Chile tiene una característica distinta a la mayoría de los países de Latinoamérica, ahora exceptuando México, porque tiene una legislación ya en vigencia hace 4 años que regula el tema plataforma. Y para nosotros como central es fundamental esta discusión en la CID por un fenómeno que se vive y que está cotidianamente en nuestro país. Y es que para nosotros esta discusión no solo limita al trabajador de plataforma digital, sino que de alguna forma va a permitir algún tipo de regulación para las nuevas formas del trabajo. Nos va a dar un pie para poder legislar hacia otras formas que todavía no hemos podido definir, ni palpar, ni concretar. Hoy día en Chile el comercio, el gran comercio, las grandes tiendas, el gran retail, está trabajando con aplicaciones. Y está trabajando con aplicaciones no como las que conocemos, Uber, Didi, o sea, en fin, cualquiera de esas, sino que con aplicaciones propias donde contratan a trabajadores por horas, quitándoles todos los derechos, porque nuestra legislación, la chilena, abarca solo trabajadores de plataformas, específicamente los que hacen transporte y delivery. Entonces, esta legislación, que en su momento fue, o sea, catalogada a nivel mundial, digamos, como una legislación pionera, después de 3 años de evaluación, podemos definirla como bastante no tan pionera, porque eh, no, la resistencia de estas empresas a cumplir con la norma es brutal. Entonces, ¿cómo vemos nosotros las necesidades que tenemos hoy día? Porque si yo hago la comparación entre el informe azul o el blanco o todos los que han ido apareciendo, es muy similar a la ley que tenemos en Chile. Asegura un mínimo, mínimo, mínimo. Pero después de 3 años yo puedo decir algo positivo de la ley chilena. Y es que ha permitido que los trabajadores de una u otra manera, con todas las peleas que hemos tenido, tengan un mínimo de seguridad social, tengan un mínimo eh, de, de, de identificación incluso propia como trabajadores, que es algo que romper esa cultura del colaborador o del socio o del que es el enganche, digamos, o el ser pyme, digamos, o el ser un trabajador independiente que genera dinero cuando uno quiere, esta ley ha permitido precisamente que nos concretemos y nos sintamos trabajadores, que parece mínimo, pero la verdad es que es una tremenda pelea cultural, una ganancia cultural, y hoy día nuestra discusión hacia la CIT tiene la base estructural precisamente de la ITUC, que también a la que pertenecemos, ¿no? No discutimos, sabemos lo necesario que es tener un mínimo de base para poder apoyar a los países que no tienen reglamentación. Chile tiene una posición, digamos, un tanto solidaria, con el interés también de poder tener un convenio internacional para poder apoyar esta ley que tenemos y generar leyes para los otros tipos de trabajos que se nos están viniendo encima y no tenemos cómo regular o cómo enfrentar desde la legislación. Entonces, tenemos intransables igual que todos nosotros, o sea, igual que todos los que vamos a escuchar ahora. Yo podría tomar la presentación de la compañera anterior y la pongo y es exactamente lo mismo. Y es la lucha que tenemos internamente también en Chile. La necesidad de que sea un trabajo. Aquí en Chile la legislación permite tener dos tipos de trabajadores. Hoy día el informe azul no define un trabajador. A nosotros nos gustaría que lo definiera como un trabajador dependiente, por una situación completamente evolutiva de nuestra ley. Todos los problemas que no responde la ley o que existen porque no se hacen cargo las empresas de cumplir la ley, se resolverían si los trabajadores fueran dependientes, con libertad de horario, con todos los beneficios, pero en relación de dependencia. Sabemos que eso es difícil, pero es una de las posiciones que a nosotros nos interesa igual defender. La defendimos hace un poco de tiempo atrás en una comisión tripartita de esta evaluación de esta ley, junto con las empresas o los representantes de las empresas, vamos a decir, el gobierno y los trabajadores y las trabajadoras. Entonces, creemos que esa es como la fantasía. O sea, realmente tener trabajadores en relación de dependencia es la fantasía. Si no se puede trabajadores en dependencia como declaración universal, creemos que el trabajador independiente debe tener los mismos derechos que el trabajador dependiente. Es decir, trabajo decente para todos, sea en calidad de independencia o sea en calidad de dependencia. Esa es una pelea que estamos teniendo aquí en Chile. O sea, a nivel legislativo. O sea, a nivel legislativo hasta marzo, que tuvimos un pequeño cambio de gobierno y que nos tiene un tanto complicado. Pero tenemos un mecanismo acá que se llama Consejo Superior Laboral y que es un mecanismo tripartito de legal, ¿no? O sea, que obliga a través de diferentes convenios de la OIT a mantener diálogos tripartitos. Y en este Consejo Superior Laboral es que se decide tener esta subcomisión de trabajo en plataforma y observación de la transformación del trabajo. Y eso queremos sostenerlo. O sea, la pelea hoy día con el gobierno es sostener este tipo de estamentos que ya estaban preestablecidos. Entonces, cuando hablamos de trabajo decente, ¿qué queremos? Queremos seguridad social. Pero no una seguridad social que sea así como la que nos funciona hoy día a nosotros, que es como nominativa. El trabajador en Chile es el que entrega su dinero para su seguridad. Queremos asegurar que a lo menos las empresas también formen parte de esta responsabilidad. Nos gustaría, y siempre hablo en gustaría y en el querer, porque al final esto es una gran negociación colectiva. Los que hemos trabajado en mi área de trabajo, nosotros tenemos negociación colectiva con Uber como empresa y sabemos lo difícil que es negociar colectivamente. Y esto es mucho más grande, porque aquí habemos disímiles posiciones, no solo de los trabajadores que en general tenemos una misma, o sea, queremos protección social, queremos derecho a sindicalización, queremos tener algún punto de control en el algoritmo, queremos abandonar esta caja negra que nos censura, nos cancela, nos impide trabajar, queremos transparencia en los salarios, que también es muy importante a la hora de hacer el trabajo, porque uno cuando hace un trabajo independiente, sacándonos del área de las plataformas, siempre sabemos qué es lo que vamos a hacer y cuánto vamos a ganar. Acá el algoritmo juega con la demanda, entre comillas, digamos, porque en realidad uno intuye que negocia con la demanda porque no tenemos acceso a estos algoritmos. Nosotros queremos fiscalización también. Y eso es darle poder a las direcciones del trabajo o como se llaman en sus países, la posibilidad de fiscalizar y asegurarse de que los salarios sean correspondientes a lo que tengan definido en cada país. En Chile tiene una definición sobre el salario mínimo. Todavía, 3 años, 4 años de aplicación de esta ley, nosotros no hay forma de fiscalizar o de saber si realmente están cumpliendo con este mandato legal. Por lo tanto, no, a nosotros nos gustaría que al haber libertad sindical haya protección a los dirigentes sindicales, cosa que hoy día no ocurre. En la mayoría los dirigentes sindicales, en un principio, hace un par de años atrás, estaban escondidos. O sea, eran reuniones secretas. Yo me acuerdo de esas reuniones casi de onda, esconder a los trabajadores dirigentes para que no supieran las empresas que existía un sindicato formal o existían trabajadores que estaban teniendo liderazgos. Protección para los dirigentes sindicales, protección de datos, porque la verdad es que uno al final va definiendo algunos negocios y uno puede así intuitivamente, sin necesidad de grandes estudios, darse cuenta que hay empresas y dices, pero ¿por qué siguen trabajando si no tienen ninguna ganancia? Pero el data mining es brutal. Y eso para nosotros también es un punto importante. Chile tiene una ley de protección de datos, pero que está enfocada más bien al dato personal, pero un dato personal más bien hacia el área comercial. Una ley que va a empezar a funcionar este año, en diciembre, y que esperamos nosotros poder enganchar con nuestra ley para tratar de sujetar la extracción de datos. Y obviamente está el tema del respeto al trabajador, porque aquí nos vemos enfrentados cada día a situaciones donde la dignidad del ser humano se ve violentada. Entonces ahí hay otro punto hacia las empresas de la responsabilidad de proveer espacios de protección. Y hay un punto que se dejó de lado en este informe azul y que nos dejó a todos para adentro cuando lo fuimos leyendo y después cuando tuvimos la oportunidad de compararlo, y es el tema de género. Y sabemos que los trabajadores de plataformas en ciertos aspectos son más hombres, pero en otros son muchas mujeres. Y la verdad es que cuando uno no protege convenios de maternidad, convenios mundiales de maternidad y de cuidado, cuando uno no protege a la mujer, que también es la que en su mayoría, en la mayoría de los países, es la principal proveedora de un hogar, estamos retrocediendo 100 años. Entonces, para nosotros el tema del rescate del enfoque de género o el de proveer en alguna es algo que vamos a tener que ir peleando y espero que ahí nuestros, nuestra mesa negociadora pueda de alguna forma hacer entrar un poco más el tema. Sabemos que está difícil, eh, sabemos que este año es la discusión. Yo estoy esperanzada, pero con miedo. Y, y yo creo que acá va a depender mucho de la habilidad de la mesa. Aquí le tiro la pelota a Mónica Teff, porque ella está ahí y ella tiene que aguantar las penas y las alegrías de todos nosotros. Tenemos la suerte de Chile, en Chile, de que yo pertenezco o más bien hice el trabajo entré a la CUT siendo chopper de aplicación y tengo un cargo en una situación privilegiada que no le pasa a todos los trabajadores. Y entonces uno se encuentra en estos lugares grandes donde hay poca representación de trabajadores. Hay trabajadores, pero que vienen de las grandes centrales que no tienen una conexión real con el mundo del trabajo. Este año yo sé que se va a hacer un esfuerzo de llevar alrededor de 10 trabajadores reales, ¿no? Concretos. Sería bueno que nos volvieran a escuchar, porque es ahí donde realmente en Chile se dice las papas queman, en otros países dicen las castañas están calientes. Es ahí donde los trabajadores, o sea, donde se puede entender exactamente la necesidad del trabajador. Nosotros queremos un salario digno, queremos respeto como trabajadores, como personas, queremos respeto hacia las mujeres, queremos facilitar espacios de trabajo para mujeres, queremos que haya de nuevo seguridad social asegurada, que, y, y, y la verdad es que estas grandes discusiones lo que permiten es crear una base para que cada uno en sus países venga a trabajar. La compañera de atrás hablaba de esta responsabilidad a nivel global, también creemos que es necesaria. O sea, Uber no puede comportarse, voy a poner ejemplo Uber, no puede comportarse de una manera A en Europa y comportarse de una manera B y C en el sur global, donde vamos mucho más deteriorados, o sea, más precarizados que en el resto del mundo. Yo creo que ahí se me está acabando el tiempo. Yo quiero dejarle más tiempo a Mónica porque ella tiene la estrategia y es súper importante escucharla porque en realidad no está en desentono de lo que todos nosotros vamos a hablar acá, y eso yo lo puedo asegurar. Muchas gracias a todas y a todos. De nuevo, es un buen espacio y es bueno que nos escuchen.
Thank you so much, Angelica, and lots for Monica to sort of react to later. But first, let me move to Mercy. Mercy, if you'd like to come in, I know you've been working with several platform workers groups, including data workers, but others as well, and we'd love to hear from you.
Thank you so much, Saloni. Let me just pull up my screen. Please let me know if you can see the projection. Okay, good. Hello, everyone. My name is Mercy Mutemi, the Executive Director at the Oversight Lab. Our focus is building tech that is anchored on human rights, and we work with communities. A key pillar of the work that we do is labor, and in that we work with unions, associations, and movements in African countries to advocate for a fair and equitable tech future. So I'll give the background to this presentation and then proceed to it. So to contextualize, in Kenya, the conversation on fair working conditions for tech workers generally began in litigation. So a lot of litigation from the ride-hailing sector, and very notable litigation from the content moderators, including ongoing human trafficking cases against Meta in Kenya. And those cases have been very precedential in setting the standard, including standards on accountability of tech companies that are not registered within the local jurisdiction. So, for example, in the content moderation cases, the Court of Appeal held that it doesn't matter how corporate structures are set up, and we know that they set up corporate structures to evade liability, as long as workers can make claims of human rights abuses, especially of a grave kind, then courts in Kenya, from a human rights perspective, can assert jurisdiction over them. And to counter this, the platforms lobbied the government, and the government introduced the Business Laws Amendment Bill at the end of 2024 to reverse that. And specifically, it was providing for immunity for tech platforms. So any worker that is employed through third-party engagement, including ride-hailing workers, would not be able to go after the platform company or the parent company. They can only sue the company that they can see, which we know is very detrimental because the parent company usually controls the algorithm and all the factors of production. That moment ended up being a catalyst force for workers coming together from the ride-hailing sector, which was already traditionally organized, the content moderators who had been going through litigation, and AI training workers who are the data labelers, the data annotators that are organized either in unions or associations or independent workers. And they all came together to form the Africa Tech Workers Movement to advocate together. That process also led to serious deliberations of the legal gaps that led to exposure to harm. As a counter to what the government was proposing, the government was proposing amendments to the employment law that were deeply harmful. So the workers used this as a moment to come up with independent suggestions of what a fair legal framework would look like to protect the workers. So because the Africa Tech Workers Movement is fairly new, it had not been involved in the ILC process up to this point. It was actually through our collaboration with WIGO that they brought us into this process. So our interactions with the Blue Report has been going back to what the workers had already identified as the key areas of change, and looking at the draft of the Blue Report and making recommendations on this is what we had already identified as fundamental problems. Remember, we are dealing with a fairly progressive jurisdiction as far as legal protections are concerned. So a lot of it is looking at the gaps as opposed to the general problems. So we are not just listing all the problems the worker face. It's what would need to change on a fundamental and conventional level to trickle down to our country, which is monist in nature. Once it is accepted at the ILO, at the ILC process, then it becomes automatic law here. So that is the background underlying this presentation. So the first sort of big silo of issues is the issue of legal protections. And what we mean by this is the minimum working requirements, including on time, including on maternity leave, overtime payments. The thing that we refer to as this worker is entitled to this is what we think of as minimum working requirements. The occupational health, that also feeds into it, social protections, freedom of association, and the right to unionize. When we say legal protections, that's what we mean. What is the problem? The problem is that this is limited to traditional employees. So any worker that is engaged in a structure that is not anticipated in a contract, whether fixed term or permanent contract, is kept away from these protections, which are crucial in themselves. And the solution that we propose is to focus on workers and not employees, because the language that focuses on granting employees rights ends up being detrimental to workers who don't fit into that category, and gives governments an out where they can categorize workers into employees and other groups, and then just limit the protections to employees. So for example, in an example of good drafting language would be our constitution. So our labor rights provision is Article 41 of the Constitution, and its language is that every person has the right to fair labor practices. So you're grounding the right on people in whatever situation that they're organized. And 41.2 talks about every worker has the right to. So adapting language in the convention that doesn't limit rights to specific groups, but rather sets the standard of the right generally. What that translates to as per country is making sure that countries have a minimum standard to adhere to. When you restrict it at the convention level, then countries feel, oh, we don't really have an option but to restrict this the same. So you start broad and then trickle down. And we'll go into the classification issues, but as a starting point, all protections should apply to all workers. As a country, you can choose to go forward and categorize different workers, call them employees, dependent contractors, independent contractors. You can proceed with whatever classification you want to, as long as the basic legal protections are attached to workers generally and people generally, not to employees. The other issue that we have with the language of the text is the dilution. There seems to be a very huge give and take away game that's going on with the convention. So it recognizes that there are other structures, for example, under which work may be performed that are not employment, and then proceeds to say, but the governments get to choose and independent member states get to choose what to do with that. To us, that dilutes the recognition that you'd given earlier on in the convention. So you end up not protecting workers. So just to recap, the issue we have there then is that the language itself is not neutral enough to extend to protections. And what we are specifically asking for is neutral language and removing the diluting provisions. There are a couple that are spotted throughout the text. The second silo of issues we have is around algorithmic management, and we're coming at this a little bit different, because the thing that unites the workers under the Africa Tech Workers Movement, besides being adjacent to tech, is also the role that algorithms play in their work. So if you think about e-hailing workers, if you think about content moderators and data labelers, platform workers, gig workers, it's not just the structure and the precarity of the working conditions itself, is the role of the algorithm in managing their work and also determining remuneration, terms of employment, everything about it. So from that perspective, the first issue is around forced labor. What we were thinking is, while forced labor is addressed in a different provision and it's generally recognized, there's a part around algorithmic management that is not touched on completely and is very crucial for this convention. The part where one labor input produces output for different industries. So for example, an Uber driver is not just an Uber driver. An Uber driver is also training the algorithm for Uber, is also collecting data for Uber. So for all the other work that they're doing other than the driving, they're not getting paid, right? The same way for content moderators, like they're employed to clean up platforms, but what they're actually doing is training algorithms. And when you negotiate your contract, if it's a fair engagement, you're negotiating a contract for one engagement, but the value you're bringing is benefiting different industries. And what we see that connects, what we see there connects to the wage theft we see that is facilitated by algorithms. It's the same continuum of a problem in that the algorithm determines what to pay you and how much to pay you based on the quality of your work, but that's never quite a fair assessment. So we would need some creative thinking on how to front forced labor as a key issue in this convention, because this is the moment to do that, since there's a recognition of algorithmic management. Of course, it's not adequate, but there's an entry point here for a broader discussion that algorithmic management is not just about pay, it's also about the deeper patterns that it continues to perpetrate. Further than that, there's a lack of coherence with data protection. And one of the things that is very concerning is that there are limited grounds, for example, for appeal when there's algorithmic management disputes. And this doesn't quite match to data protection principles, whether it's the GDPR or country provisions. It's almost as if we're being told workers have less rights when it comes to data protection than general citizens, in that they have very limited avenues when there's been abuse, when there's been a violation of their privacy, and when their data has been used in a way that in other contexts wouldn't be allowed by the law. So the solution here that would actually bring us closer to fairness would be to harmonize the provisions in the convention with what has now almost become universally accepted principles on data protection. So data minimization is quite the opposite of what platforms want to have, because they want more data to be able to do more jobs. But if we're able to push for harmonization with those kinds of principles like data minimization, it actually pushes the conversation on fair pay for fair work forward, in that you have to disclose why I'm collecting this data, and if you're collecting this data for a broader job that is beyond what I negotiated for, then you have to pay me fairly. So there's a solution here through harmonization, and especially for countries like Kenya, if we already have a data protection law, then the algorithmic management provisions should be up to par with that law. Okay. Then there are other issues that don't quite fall between those two broad issues, but are still very problematic. Where we see misclassification, for example, is if you go back to the text and you fix the issue of the neutral language to where rights belong to workers generally and not to employees, there's still an additional duty to address misclassification and the consequences of misclassification. Because yes, countries are going to go forward and categorize workers, and may even try and do a balancing exercise where some categories have better rights or better protections than others. That is the natural consequence of something like that, right? So there should then be a protection against misclassification and consequences on platforms for misclassification. That way, there's a duty for workers to be classified correctly. So whatever rights, whatever protections, degree of protection you agree to give, then it must be accurate. And misclassification or strategies to address misclassification can also help us with addressing the rights and responsibility question. So the work is structured in very, very different models. Sometimes it's BPO and platform, sometimes it's BPO, platform. There's so many ways they're structuring these arrangements to hide from liability. But if you have a condition around misclassification and a condition around delimit the rights and responsibilities, then you're able to address the classification problem correctly. Most importantly, there should be consequences for misclassification. And then precarity in general, I mean, it's baked into the model of gig work and tech work and even ride-hailing work, just in general. And that could either be through the non-existence of contracts or the short contracts, abuse of short-term contracts or successive contracts. And we need to figure out how to address this as a general theme, because if we manage to get the protections and still the precarity is not addressed, it's still legal to give people maybe like 2-week engagements for I don't know how long, then it sort of defeats the purpose, because this speaks to a use and dump model. So you can still exploit them legally, so to speak. And then thinking about the unilateral models like in ride hailing, where the terms are set by one person, it's not really a negotiated one. As we consider whether if the pattern was to change, where they would now look at the subscriber model, how would that be responsive, and how do we still protect workers in that model? And the thing that introduces or reinforces this precarity right now in the convention is Article 5, that shifts the burden to the workers. So it's almost as if we have a good framework on occupational health, and then Article 5 says then the worker must be supported to leave when they think that something is dangerous. But that is shifting the burden to the worker. The burden must always remain with the platforms at all times. I know I've run out of time, but in summary, our verdict is that the Blue Report is unresponsive and it's not fit for purpose. And as we say this, we're saying it's not fit for purpose right now, and it's also not fit for purpose for where we're headed. We can see the patterns that are unraveling, and companies and platforms are exploring more and more ways to be exploitative. So already we are at a bad spot. If this was to be adopted, it wouldn't help anybody now, but even where we're headed, it wouldn't protect workers at all. So it does need quite some negotiation to try and achieve the fundamentals. Then it's up to countries to enforce and to also adapt to the rest. Thank you so much for that.
Thank you, Mercy. You've clearly done so much work sort of looking through the language, and I think pointing us out to specific good practice language that, and you give the example of the Kenyan Constitution is also very useful. So thank you for that. You talked about the subscription model, and I know that that's something Nicole is going to speak about possibly. So I'm just going to hand it over to her, but thank you so much. Nicole, all yours.
Oh, thank you. I just want to really thank you for inviting the ILO to speak on the topic. We welcome WIEGO's really long experience and expertise with the ILC and everything that you've done. And so what's very exciting to me is to hear from the other women. I think we're all struggling with this issue of classification and how do we deal with that while trying to deal with these other amendments. As ILO is a federation of grassroots driver groups around the world. I think we have like 25 or 26 affiliates in 6 continents of app-based transport workers. And as we read the Blue Report, we see that it's really enshrining a lot more of the employer's priorities than what workers need. So we're actually, it feels like we're moving backwards from where we were last year. So what does that mean? And what does that mean we're able to accomplish? I think we're in this amendment process right now. And there's some issues with that. We're all going to have different articles that are entwined and amendments that will inevitably implicate each other. So how does that come together? And who makes the decisions how those come together? So that's one issue. But I think the one that is really big for us is that we cannot signal which amendments carry the most weight in this process. As unionists in the IWTW, we have a lot of experience in bargaining and campaigning, and understand that, of course, there are times when we choose to hide our priorities, but for the purposes of this closed door meeting, we really want to share our priorities. And what we want to talk about is some of the red lines that we have to draw. If we don't accomplish a couple of these, whatever we move will only apply to a very, very small sector of workers, because we are dealing with the misclassification. So for the purposes of this conversation, I would like to talk about our amendments in 3 distinct blocks, and I want to spend the most time on the red line block. So these are the highest priorities to amend, and the reason they're the highest priority is because if we don't get them, other amendments will be meaningless, or we actually could be undermining rights around the world instead of moving them forward. So there's the first category that we want to talk about in red line is the issue of the 2 classes of workers. So I'm going to get a little bit technical here. So Articles 9, 10, and 11 of the current draft endorse the idea of 2 classes of workers with 2 radically different pay and Social Security structures. Article 9 and 10 guarantees those workers classified as employees with minimum wage standard aligned with existing ILO conventions, while explicitly marking independent contractors as having no rights and no guarantees. Everyone knows that we are mostly independent contractors around the world. And it is a misclassification, but it is getting encoded in law. Here in California, where we have really strong labor rights, app transport workers are defined as independent contractors, making 1/3 of minimum wage in California. And it's law. And we have been fighting the law for 6 years. So, and that's just California. This is happening all over the country, all over the world, I mean, and we were just talking yesterday in a meeting in the UK is saying, yeah, we got a Supreme Court decision that we're workers. And guess what? They're not treating us as workers still. We can't enforce it. So, I mean, that's in the countries that you expect, in the global north, that you're expecting them to be able to tap into these rules, and it's not happening here, and it's definitely not happening in the global south. We have to figure this out. So anyway, Article 11 does the same exact thing with Social Security, again guaranteeing workers but not independent contractors any Social Security, and putting the Social Security for independent contractors as a responsibility of the state, not the company. So we have quite a few suggested amendments to accomplish unifying the workforce, despite the misclassification, which is a specific strategy of these companies to undermine these kinds of processes, whether they're happening in countries or whether they're happening in the ILO. So one is we have to conquer the distinction between remuneration and payment. We think we should use the word compensation. We understand this would require reopening the definitions under Article 1D, as well as revising Article 9 itself. The additional amendment to Article 9, besides using the term compensation, would be to include a clause that such compensation is, quote, adequate to satisfy the basic needs of digital platform workers and their families. So getting around whatever is legal, minimum wage, for workers, and just saying this is the standard for all, this is the standard for compensation for all app-based workers. We also call for the deletion of language requiring that digital platform workers be in an employment relationship in order to be entitled to these protections. So there's a point 3 of Article 9 that should be deleted, saying the member states should use the best efforts to cover non-employees, since the amendments we propose would erase the distinction in coverage between employee and non-employees. So the same thing in Article 11 with Social Security. it's getting very detailed. I will definitely get the details to you guys. It's not the how we've been talking about it here. So I'm going to go to more of a big picture. Okay. So we have to make this point that we're all app workers, regardless of how our local laws deal with us. Because we know that the companies are actively trying to get us out of any regulatory status. And our only hope to represent the most is to talk about, this is one big category. The second category for red lines relates to articles that, if we don't amend them, will create enormous loopholes for just this kind of reckless manipulation that has led these companies to erode labor law. And the newest one, which you referred to earlier, they've been forcing IC status on us, but rewriting labor laws locally. But we've just published a report in the ILO about the subscription model. So this is a new model that they're moving throughout India very quickly. And it's a model where the worker pays the company to work, and then the pay for the worker comes directly from the passenger. The way the standards are written now, these people wouldn't even be included because their pay comes from individual passengers. So we're actually not certain how to frame amendments that would address the heart of this problem. And what I would add is, this is, and once we added ones that say, see platform workers who are paid via subscription model, then they'll change another one, so it won't apply. Which is why we believe that we have to really think of the work as an enterprise, so that regardless of what new, models they come up with, that it's captured by this, the concept of an enterprise where work gets done, as opposed to any kind of model that workers are paid. So we think these categories are foundational and essential. If we risk ending up with standards with these kinds of gaping holes, whether it's dealing with employment or IC or new models like the subscription model, we think that we should be prepared to halt negotiations and propose an alternative way forward. As many of you are aware, we have been advocating for this idea of a standing committee, with the idea that such a committee could also research and document the kinds of local initiatives to regulate that I just talked about. We have good models in many different places around the world that have been able to navigate between IC and employment status and have come up with regulations that move app workers forward. We can do that. But the ILO is insisting on this bifurcation, employee, non-employee, and it's not going to work for us. So that's the red line stuff. There's also quite a few amendments that we think could strengthen, but only in the context if they apply to all workers. On the fundamental principles of rights at work, we propose that there be a sharper focus on enterprise responsibility, with language requiring members to protect workers from enterprise interference with workers' rights. This would address the kind of campaigns and lobbying against workers who are organizing or advocating for equal compensation. Second, on occupational health and safety, again, we would want language to go beyond having ILO members take appropriate measures. Instead, with greater enterprise accountability in mind. We want governments to require enterprises to take the steps necessary to protect workers, or else face consequences. The third one is around deactivation, Section 12, and dispute resolution, Section 15. Those articles need to be improved. The ILO members requiring enterprises to have policies in place addressing reasonable notice, progressive discipline, the right to appeal, due process, the right to be represented in discipline that could lead to suspension or deactivation. We have won those kinds of rights in the New York City market through regulation, and it should spread. We would need 2 new articles to address the subscription model, we think. Again, we're not sure about this. We need to make sure that folks that are paid in this way would be covered by all the legal frameworks, and again, address enterprise responsibilities and liabilities for direct payments from consumers to platform workers. And last, we need language that addresses the ongoing efforts of enterprises to replace workers with AI or automation. Uber is making huge investments in that. Right now, I think we're really dealing with AI management, therefore we're not workers. But AI running things means we don't have jobs. We need to address how to deal with that. So those are my our key moments, our key things that we want to address. I think strategically really thinking through, what if we don't get, the employment versus independent contractors stuff? Then we know that the employment stuff applies to less than 1% of the people doing this work. We can't let that go forward. What position do we take as multiple organizations around the world? Thank you so much for the opportunity. It's so great to be in this room with all the beautiful ideas. So I'll leave it there.
Nicole, thank you so much also for waking up really early for this. We saw it become night today in your background as you were speaking. Also, thank you for pushing us to think about how platforms may change models and to account for those changes in sort of our negotiations. If you have your amendments and proposals in a written form, I know that would be much appreciated because there was so much detail. So it'd be good to see that, detail as well. Thank you all four speakers. We have time for 1 or 2 questions if people have anything they want to ask our speakers. You can leave your questions in the chat. I think you can raise your hand. Bruna, correct me if I'm wrong, and we can unmute folks.
Yes, you can.
Okay, so maybe 1 or 2 questions if someone wants to ask something. I know this was a lot for people also listening in to kind of hear and process. It was very detailed. It was very impassioned. So I appreciate if you're still sort of mulling things over in your head. But I see a hand raised, so I will give it to Enoch. Do you want to unmute and ask your question? And if you can also just let us know where
Hello,
you're
can
from.
you hear me? Yeah,
Yes, just let us know where you're from and who your question's for. Thank you. Go ahead.
Yeah, I'm calling from Ghana. My name is Enoch. I'm the General Secretary of Union of Informal Workers Association of Ghana. In fact, I was very, very, very happy. And when I got to register for this program today, in fact, I joined and then later I disappeared, but still I forced to join because it's very important to me and my members. In fact, I'm happy, as I have said. So now I have put scripts on the question tab that you have even covered our advocacy issues. Because we were thinking the labor laws does not cover the informal sector very well. in various countries, including Ghana. So we advocated that there is a labor law review going on. And once we are affiliate member of Ghana Trade Union Congress, that TUC, we also share our view and what we think labor law should be to cover informal workers associations or workers. So we talked about pension, we talk about workplace safety, we talk about OSHI, that's occupational health and safety issues that are not well arranged at the places that we work, such as marketplaces on the roads, those who are selling on the head, the traders on the pedestrians are not very well arranged. So we ask government to put these things in the labor law review act so that it become a law. And also, first, we don't have voice to advocate for where we will sit, the spaces. So we also ask government to make the municipal, the authorities to engage the informal workers as a law, so that whenever any government comes and the municipal authorities is elected, they should engage the traders or the workers in the informal sector so that they will know how to arrange the people, and then going forward, we have the safety place for work. And my question is, we are doing our best. What is the internationally, or all of us are doing to support us? So that, because advocacy issues is not an easy thing to take or to go by. What are you doing to support us in course of advocacy or research, so that in all
Great.
we will all achieve whatever we want to do in the informal economy in the global. Thank you very much.
Thank you. Thank you so much for that. What are we doing to support workers? That's pertinent. But I'll get two more questions. Pami and Jose. Also, if you could keep your questions short and to the point, please.
Good morning, everyone. I'm Pami. I work for WeGo. I'm based in the US. And my question is just to hear a little bit about the process. I don't know who I can direct it to, but in terms of the process of drafting this, we've gotten to a version that, from the comments that are coming in, is so watered down in terms of recognizing the problems and addressing these issues. And I just wanted to find out how, has it been really challenging in terms of the negotiation, and how optimistic are we? This is just my sense check. It's a broad question.
Yeah.
I don't want to get into too much detail. Thank you.
No, thanks, Pami. I think Monica will be speaking to that later when she speaks. So I will leave that to her. But Jose, did you want to ask a quick question as well?
Sí, muy buenos días. Mi nombre es Rafael Navarro, soy de Costa Rica, secretario de Educación de la Central de Trabajadores Renovaron. El tema es nuevo, pero se ha venido abordando bastante fuerte, gracias por el tema de la OIT, la CSA, la CSI. Yo tengo una inquietud muy puntual, porque en Costa Rica el tema de la organización, por ejemplo, de trabajadores en plataformas digitales está empezando apenas. De hecho, como central estamos haciendo acercamiento con trabajadores. Algo que he descubierto, y es que hay un temor muy grande que ciertas plataformas amenazan que en el momento que se organicen, salir del país. He estado ayer y antier en algunas actividades también, he escuchado ejemplos, por ejemplo, de Kuwait, de otros países donde han podido afrontar eso. Sin embargo, ¿tienen algún ejemplo de que alguna de esas plataformas realmente haya realizado el abandono? Porque obviamente decir, por ejemplo, para las plataformas como Uber, me voy de un país no es tan fácil, no creo que sea tan fácil porque es muy oneroso para ellos. Pero ¿tienen algún ejemplo de que efectivamente hayan podido cumplir esas amenazas si después han vuelto? Porque puede ser que digan, me salgo de Costa Rica, pero no les conviene y vuelven a retomar. Porque ese es el tema más grande que tenemos en el tema de las tecnologías, que la gente, como estamos empezando apenas, dicen, y si se va la empresa, si se va la plataforma, ¿qué hago después? En Costa Rica hay una singularidad. Mucha gente que trabaja en este tipo de plataformas no depende solamente de eso, tienen uno o dos trabajos más. Entonces, quizás sienten que si pierden el tema de la plataforma, no es que se van a quedar sin trabajo en algunos sectores, ¿verdad? Esa es mi pregunta. Muchas gracias por el espacio.
Thank you, Rafael. I think that's a very relevant question. And there are examples of platforms leaving also, but I think this is an older case, even in informal employment, when regulations are tighter, more worker oriented, there is exit of capital. Actually, that is a really good segue to our next speaker. Karina, I know you're here. Brazil has been doing some work in organizing platform workers. I know there's been a lot of discussion around the Blue Report, and we would really want to hear from this context. Just a quick note, Omar, I saw your hand up, but if you can leave your question in the chat, that'll be great. Kaka, over to you. You're on mute. You'll have to unmute to speak.
Ok. Bom dia, então, sou motorista de aplicativo aqui no Brasil, né? Trabalho há quase 10 anos como motorista de aplicativo. Ano passado estive na OIT, onde a gente levou também algumas questões sobre regulamentação de gênero, para regulamentação com perspectiva de gênero também. Faço parte de grupos internacionais e grupos latino-americanos de mulheres trabalhadoras de aplicativo, que também é uma preocupação nossa. E aqui no Brasil, vou dar um parâmetro mais ou menos de como que está a situação no Brasil. O debate está sendo amplamente, nós estamos amplamente debatendo a questão da OIT, né? Tivemos ontem uma reunião com vários trabalhadores, motoristas, entregadores, de bike, de moto, né? Aqui tivemos semana passada uma manifestação a nível nacional contra uma regulamentação aqui no Brasil que simplesmente ia apenas regularizar a superexploração do trabalho de aplicativo, dizendo que os trabalhadores eram autônomos e que as plataformas teriam direito de continuar explorando e piorando cada vez mais o trabalho de aplicativo aqui no Brasil. Então, os trabalhadores ficaram revoltados, a gente fez uma grande manifestação, fizemos em Brasília, inclusive, onde tem o Congresso Nacional, onde estava tendo essa lei está em andamento, até eles retirarem essa lei de pauta, né? Porque é uma lei que não representa os trabalhadores, é uma lei que vai contra o que a gente está debatendo na OIT, não tem nada que traga de benefício para os trabalhadores, a não ser a questão da previdência social, mas o restante só acaba realmente validando a superexploração, né? Principalmente o trabalho das mulheres e principalmente também a questão do algoritmo, né? Quando a gente tem mulheres, que aqui no Brasil já tem, inclusive, estudos, né? Que as mulheres recebem corridas menores, recebem sempre as últimas corridas quando está num grupo de homens. Acho que isso é importante falar também. E os sindicatos, junto com associações, junto com outras lideranças, estão fazendo essa busca por melhorias aqui no Brasil, por regulamentação justa, para que a gente tenha, que a gente seja denominado trabalhadores de plataformas digitais, né? Para que a gente tenha direitos minimamente garantidos, como KM mais tempo, que é uma coisa que a gente busca muito aqui no Brasil, porque tem plataformas que pagam 80 centavos o quilômetro rodado, tem plataformas que pagam 5,88 uma corrida mínima de até 4 quilômetros, acabando aí super explorando o trabalho de todos os trabalhadores. E a gente ainda tem aqui a questão dos trabalhadores imigrantes, que muitos vêm da Venezuela, vêm do Senegal para cá para o Brasil, e acabam também entrando no aplicativo. Temos também a questão eu faço parte de um grupo nacional de trabalhadores informais, onde a gente faz esse amplo debate também, porque a gente sabe que tem lugares e categorias que não tem, que ainda não tem aplicativo, mas que vai estar, em seguida vai estar dentro de algum aplicativo, vai poder ser contratado por algum aplicativo, como já tem domésticas, como já tem babás, como já tem outras categorias, né, que a gente sabe, bancários também já estão nos aplicativos. Então, esse debate é nível global, né? É importante salientar que eu vou listar algumas coisas que a gente tem preocupação também, tanto na questão das mulheres, né, como na questão de uma regulamentação justa com perspectiva de gênero. É um documento que a gente tirou em 2023 com mulheres trabalhadoras de aplicativo da América Latina, que eu acho que é importante a gente sempre relembrar que as mulheres têm que estar sempre tentando estar nesse espaço, tentando estar nesse debate, porque senão eles patrolam a gente, desculpa o termo, e passam por cima e acabam não garantindo nenhum tipo de direitos nem para as mulheres. Então, a gente entende que, que tem que ser cumprido as convenções da Organização Internacional do Trabalho, a número 100 e a número 111, que trata da discriminação em matéria da ocupação e emprego. As convenções 97 e 143 que trata sobre os trabalhos de imigrantes e convenções sobre a proteção da maternidade, que é tão importante para as mulheres. As regulamentações específicas que garantam transparência algorítmica, que é o que eu falei há pouco tempo. As mulheres, quando estão num grupo de homens, tu liga todos os aplicativos, chama primeiro para os homens brancos, depois para os homens negros, depois para as mulheres brancas e por último para as mulheres negras. Tem já pesquisa aqui no Brasil que já identificou isso. Então, a gente sofre com essa questão da subordinação do algoritmo, né? A questão também que se tenha a supervisão humana, alguém já falou aqui também, é muito importante na questão dos bloqueios, né? Nós sofremos muito aqui com bloqueios de motoristas que tiveram algum problema criminal há 10, 15 anos atrás, quando a Uber nem fazia parte, quando nem existia a plataforma, e sofrem com o problema dos bloqueios nas plataformas sem chance de se defender. E aí o motorista foi lá, ele alugou um carro, ou o entregador comprou uma moto, ou comprou uma moto, um carro de mais de 100 mil reais, tá na plataforma para garantir o sustento da família e é bloqueado e não tem chance de defesa. Sobre a questão da violência, regulamentação que gere obrigações por parte das empresas. Hoje a gente vê que muitos lugares têm regulamentações que as empresas não têm nenhum tipo, não tem nada. Simplesmente todos os direitos são das empresas e os motoristas, os trabalhadores, os trabalhadores em geral, só têm deveres, né? Não tem nenhum tipo de direito. Isso é muito importante. Ter um protocolo anti-assédio e gerar processo de conscientização sobre violência de gênero. Não é só a plataforma botar um videozinho lá que a pessoa nem vai olhar, mas é a plataforma obrigar, como na época da pandemia tinha aqui no Brasil, você entrava no aplicativo e era obrigado a ler um documento, dar ok, ver um vídeo, né? Os motoristas eram obrigados. Os passageiros não eram, a gente tinha muito problema com os passageiros na época, porque os passageiros não eram obrigados a ver o vídeo, mas os motoristas eram obrigados a ver vídeo e a gente tinha muito problema com os passageiros. Então, ter alguns tipos de protocolo que realmente desse essa importância para a questão do assédio, para a questão da violência dentro do carro, para a violência em cima de uma moto, para a questão da violência com o cliente, né? Diretamente, o pessoal das motos, das bikes sofre bastante com isso, e porque a gente sabe que regulamentações estaduais ou municipais acabam não dando conta disso. Então, vindo uma coisa de fora, acho que é importante. Regulamentações que tenha cumprimento das convenções 17 sobre indenização por acidente de trabalho, que isso é tão importante que a gente sabe, motorista, o entregador está ali trabalhando, não tem nenhum tipo de indenização quando sofre um acidente de trabalho, quando sofre um assalto. Temos colegas aqui que foram vítimas de latrocínio, roubo seguido de morte, né? Trabalhando com passageiro dentro do carro, assalto pelo próprio passageiro, e as plataformas, se tu não entrar na justiça, não comprovar que aquele motorista estava trabalhando ou aquele entregador, a família fica sem nada, sem o trabalhador, não traz o trabalhador de volta, né? Infelizmente não traz, mas daria uma segurança financeira para a família que perdeu aquele ente querido. Acho que é uma coisa bem importante para se ter uma regulamentação internacional também. É uma coisa que as plataformas têm que realmente garantir. Apoio à mobilização de recursos, cooperação técnica que apoia a concepção de programas e projetos para sindicatos e plataformas digitais. E isso seria um pedido mais específico para a OIT, que a OIT, a gente sabe que a OIT pode fazer isso. Aqui a gente está tentando fazer com os trabalhadores informais, do qual eu faço parte, cursos de formação, né? Um apoio mais incisivo da OIT nos países que têm escritórios de OIT. Apoia mobilizações e recursos que facilitem a implementação de projetos que promovam um trabalho decente em torno do conhecimento compartilhado, lacunas regulatórias e oportunidades de melhorias no setor das plataformas digitais, com foco de gênero, acho que também é bem importante. E acredito que também poderia ser feito um estudo regional sobre condições de trabalho nas plataformas digitais a nível global, para que a gente saiba como que funciona o trabalho aqui. A gente sabe, porque através dos debates a gente sabe, mas tem um estudo validado pela OIT, onde a gente consiga realmente saber como funciona o trabalho de plataforma digital aqui, no México, nos Estados Unidos, em outras cidades, né, que já tem regulamentação ou que não tem regulamentação, acho que seria bem importante. Assistência técnica para o desenvolvimento de legislações nacionais sobre as sobre as plataformas digitais com foco em gênero, acho que também seria bem importante. Então, aqui no Brasil, a gente está em cima do Congresso, a gente está tentando fazer maneiras, lembrando que nós, sindicatos aqui, eu faço parte de um sindicato, a gente não tem cartas sindicais, a gente ainda não tem uma categoria criada. A recém saiu um código de ocupação brasileira para motorista de aplicativo, os entregadores têm, mas os entregadores têm uma lei nacional que vem lá dos motoboy, motoentregadores, que não era de aplicativo na época, e os sindicatos estão tentando se adequar. É importante que os sindicatos sejam reconhecidos, a gente sabe que tem países que não são, né, assim como no Brasil, sindicatos de plataforma, para a gente poder dar continuidade a esse trabalho tão importante que é dos sindicatos com a categoria e a nível global, né, que eu acho que é uma coisa fundamental para o país. Deixa eu só dar uma olhadinha no meu rascunho aqui, que eu tenho mais umas coisinhas para falar rapidinho. Aqui a gente tem também a questão das entregas de carro pela Amazon, Shopee e como Rap, né? Aqui a gente não tem Rap, mas tem Amazon e Shopee, que também é uma coisa que a gente tenta tratar diretamente com os trabalhadores, que sofrem várias penalidades, que sofrem com o tempo excessivo, uma carga excessiva, que vai além do limite do veículo, né? Coisas que a gente está tentando também negociar, e é difícil, porque as empresas não negociam com a gente, as empresas não querem negociar, não querem sentar para conversar, então a gente tendo essa questão de estar no OIT, de ter uma regulamentação global, a gente sabe que é difícil. Ano passado a gente teve lá, e para qualquer coisinha que se mudava no texto, a Mônica estava lá também, era assim, 2 dias para discutir uma vírgula no texto, né? E tudo que vai de encontro a trabalhadores, que é para melhorar a vida dos trabalhadores e trabalhadoras, que é para dar direitos, eles vão ser sempre contra, e não à toa a vice-presidente das empresas é da Uber, né? E esse ano a gente sabe que vai ter uma maior incisão, ano passado já teve, dos Estados Unidos, né? Junto com o bloco que eles fecharam contra os trabalhadores, então é importante que a gente esteja nesse processo, que a gente leve as demandas e muito mais. Esteja lá e fale em nome dos trabalhadores, quem puder estar lá, né? Leve as reivindicações dos seus países para a gente poder junto montar o nosso bloco junto com os nossos países que estão a favor dos trabalhadores, para que se tenha o máximo de direitos e regulamentação justa para os trabalhadores, motoristas, entregadores e entregadoras e de outras categorias que já estão no aplicativo. Eu também faço parte do grupo Global Works Solidarity, né? É um grupo que a gente montou ano passado, como a Cristi falou aqui, é um grupo que já vem debatendo há muito tempo. A gente vai ter um encontro agora no Quênia, né? Agora em maio, para tirar as demandas dos outros trabalhos de plataforma que a gente sabe que já estão, que aqui no país não tem, mas no países deles tem, para poder levar para quem já vai estar lá dentro, que a sua central sindical vai indicar, vai poder levar essas demandas para lá e a gente poder reforçar o que os trabalhadores e trabalhadoras querem. É claro que a gente sabe que a gente não vai conseguir conquistar tudo, né, que a gente quer, mas a gente tem que levar, reforçar e reforçar com os países da gente, principalmente. Aqui, a gente faz um trabalho incisivo com o governo. E foi muito através desse trabalho que a gente fez o ano passado com o governo até estar na OIT e eles apoiarem que se tivesse a recomendação, e a gente conseguisse ganhar no voto lá na OIT a questão das recomendações e da convenção específica para os trabalhadores de plataforma. Acho que essa ideia de se manter um comitê permanente, eu acho excelente, né? Que se tivesse uma, duas representações de cada país é importante para que continue a gente pressionando os governos, porque não adianta ter convenção e ter as recomendações e a gente não pressionar o governo dos nossos países a realmente entrar a fazer o que está ali e colocar nas regulamentações dos países o que realmente foi decidido na OIT. Porque a gente vai para lá, a gente debate, a gente tira o que a gente quer e aí a gente não consegue com o nosso país que se tenha. É um trabalho árduo, é um trabalho complicado, né? É um trabalho que é desgastante, a gente tem que estar lá. Começava às 8 da manhã e teve dias que terminou meia-noite, quase 1 hora da manhã, mas é importante porque isso vai determinar o trabalho de plataforma do mundo todo, é a nível global, e eu acho que é muito importante a gente conhecer o trabalho dos outros países também e o que vem sendo feito nos outros países. Então, eu agradeço muito por esse espaço. É um espaço onde a gente troca aprendizagem, onde a gente aprende um pouquinho mais, onde a gente pega alguma coisa que tem do país e a gente possa trazer para o nosso país e trazer para a nossa categoria, para as nossas regulamentações também. Muito obrigada pelo espaço. Não sei se eu não passei do meu tempo.
Thank you. Thank you so much, Karina. I think I'm also appreciative that you pulled out commonalities with what Nicole said and Angelica said, maybe. So there are common positions, which is good to hear. Monica, lots of work for you. But before I turn to you, Fish is here as well from ITWF. Fish, I know you're going to focus on the domestic workers sector and platformization. But while you do that, it would also be great if you can bring in some knowledge from, this. You've been engaging with ILC for a few years. What is it from the informal sector and the informal employment space that we can also take from into the debate in June? Fish, all yours.
Thank you so much. I think I will be short because what you have all said is very, very rich and already tackled the key matters when we are talking about platform workers or informal workers or the general definition of workers. A little bit of reflection of how the domestic workers organizations and unions back in 2009 to 2011 when we fought for the C189, the International Labour Convention on Domestic Workers. At that time, what was very key is number one, most domestic workers are not organized in unions. When ILO is tripartite, employer workers, which is usually union, and then government employees and unions workers, then domestic workers are not in the unions. But at that time, we have been stressed again that under the ILO definition of union is workers' organization, is workers. So we domestic workers, although we cannot be allowed to register union in most of the countries at that time, we are still recognized as workers in the ILO tripartite structure, although we are not an affiliate of the National Trade Union Centers at that time. So the other thing at that time, similar to this debate on platform workers, whether domestic workers are workers, when traditional mindset see domestic workers as maid servants, etc. But it has been mentioning a lot that the definition of workers in the ILO actually is defined in a broad sense. I still remember 2 years ago when I attended the first session when Manuela Tomei of the ILO was explaining the draft text of the platform workers instrument, the first thing Manuela Tomei was telling us, the ILO's definition of workers is defined broadly, and that includes self-employed workers. So that is what ILO is supposedly to be broad, and ILO set standards, which is international standards. But when we come to the negotiation with a tripartite structure, with member states, with the governments, their mind is very much bounded by their own national legislations. The problem is the major national legislations are very much bounded by and define workers in employment relationship, meaning you have employer-employee relationship, and 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 most national government member states, they are so worried if they have a very broad convention or instrument that cover workers in a broad sense, then they cannot cover much or they cannot ratify. Although ILO instruments often provide clauses that that allows flexibilities. So I still remember very freshly when we were fighting for the Domestic Workers Convention. At the end, we lost a clauses on the definition of domestic workers, that the definition of domestic workers exclude those workers who are working like sporadically or occasionally, because it was very much the European governments at that time saying that, oh, they don't want to include au pairs, because the au pairs are very much working as domestic workers. At that time, we lost that because when we came to negotiation, the member states still very bounded to their own national legislation. So we lost that. So the same thing I can really feel happened again in the platform workers negotiation. The member states are very worried about like expanding the scope of definition of workers, although we are talking about international standard. Yeah. So international standards should be broader. This should be the principle. It should be a guidance for the world, for the countries, what is supposedly we should do to protect workers. And the platform workers I can see is very much repeatedly mention the misclassification of work that has an underlying meaning that actually platform workers are workers, especially under the conventional definition of employment relationship, but because of blah, 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 they fall out of the labor laws. That is also because of the limitation of the current employment acts or labor laws usually stipulate only the workers in employment relationship, and that means what it means is the workers should be under the control of the employers, under the subordinate relationship by the employers, and they have some contractual relationship with the employer. But the world has shown that there have been increasingly new types of work that the current existing labor laws has not been able to cover most and majority of the workers. And for us, I came from a union, so I know very well what the unionists are thinking. The thing is, we do need a reformation of the current labor law that can tackle different types of workers, which we should have some principle of universality, universal protection and coverage for all kinds of workers. When we can talk about living wage, not just minimum wage legal protection, how come we cannot broaden the definition of the workers? And I can see very much the member states either they are discussing whether the workers in platform can be brought into the existing law, or they see these platform workers as third category of workers that uh, governments apply less protection to these types of workers. So in summary, we for this platform discussion, of course, we have to fight hard, but at the same time, it is not only the debate on the platform economy, but how we can move for a workers' movement that we can have labor law reform to have workers defined in a broad sense, and also like what the ILO originally defined what workers is. That include the self-employed workers, subcontractor, part-times, etc., etc. And also, we have to remind that the ILO is the standard set by the ILO is international standard. It should be more bold. It should be more on principle base that can cover as many workers as possible. And also, the third thing I would like to highlight, we should keep engaging with trade unions, how we can make labor law reform and broaden our understanding on who and what are the workers. Thank you so much.
Thank you, Fish. Thank you for reminding us that, this is an international standard that will be set, and it gives sort of precedence to future regulations also. And also for your past experience with Convention 189, I think it's really important to draw from that and take that into the fight in June. Monica, I'm going to turn to you. There's a lot for you to, I think, talk about. I know you have specific things you want to address, but also if I can ask you to speak to, some questions that were brought to you by our panelists. I think Nicole had something for you, Angelica did, Kaka did, but also Pami had a question on what is the temperature check? What are we feeling going into June? So the next 10 to 12 minutes are all yours.
Muchas gracias, Aloni. Nuevamente quiero agradecerle a Wico por organizar este webinar, por invitarnos y también por todo el trabajo que estamos haciendo junto a ustedes, junto a todos ustedes en los últimos años, porque esta es una lucha que venimos en conjunto, sobre todo, bueno, y creo que también va, por ahí arranco por lo que preguntó Pam, pero después quiero hacer referencia a varios comentarios, tomé nota y por supuesto voy a apreciar si luego nos mandan, ¿no?, las enmiendas o las propuestas bien concretas, porque este es el momento para hacerlo. Pero Pam preguntaba un poco del proceso y la realidad es que a nivel de la OIT empezamos en el 2018. Lograr tener una norma en la OIT desde que se empieza a poner la primera semilla tarda casi 10 años. Y la OIT es así, nos da muchas cosas, es la única casa en donde los trabajadores tenemos voz y voto, pero no es el paraíso, ¿no? No, pero tenemos que cuidarla mucho y en este momento sí está siendo muy atacada, todos sabemos, y hay que proteger porque es el único lugar donde tenemos voto. Pero la realidad es que es lo que podemos tener también, ¿no? Eso también hay que tener esa conciencia de la realidad. Creo que que estemos todos juntos hoy discutiendo, viendo cómo nos unimos, de realidades diferentes, de sectores diferentes, justamente nutre esta OIT. Y tenemos que llevar esta voz conjunta a la OIT. Así que yo lo celebro un montón. Pero empezamos en el 2018. Y fue un proceso, por lo menos en los últimos 2 años y medio, de formularios, cuestionarios, de parte de la CCI, que tiene el rol de la Secretaría del Grupo de Trabajadores en la OIT, nos aseguramos y logramos hacer un montón de consultas, no solamente con nuestros afiliados, que por supuesto lo hacemos, y en todas las regiones, sino que también con todos ustedes. Hemos trabajado en conjunto un montón para recibir, para debatir, para entender las necesidades y lograr poner prioridades en común. Somos de un movimiento muy grande de distintos sectores, con lo cual no es que tenemos que estar 100% de acuerdo todos, ¿no? Porque eso sería imposible, pero sí unificar las prioridades y saber que somos una organización transparente, democrática, que tenemos que también evaluar y de esa manera proyectarnos. Pero creo que hay algo que plantearon, que planteó Nicole y que plantearon varios que tiene que ver con, bueno, vamos a tener que elegir nuestras batallas, ¿no? También esto de las líneas rojas, ¿no? ¿Cuáles van a ser las líneas rojas? Y por ahí, antes de entrar y a lo concreto, Pam, no me quiero olvidar. El año pasado la discusión fue muy difícil y fue muy difícil por muchos motivos. Nosotros veníamos con una campaña y cuando hablo nosotros me refiero a todos nosotros porque yo realmente quiero creer que estábamos, que pudimos proyectar en las prioridades las necesidades de todos, de tener un convenio que sea amplio y que aplique a todos los trabajadores. Lo dijimos desde cero. Y Wigo sabe mejor que yo que eso es muy difícil de la OIT. Lo saben perfectamente, pero lo logramos porque tenemos un instrumento que va a abarcar a todos, en la informal, en la economía formal, informal, sector público, privado. Y para nosotros es clave que cubra a todos. ¿Por qué? Porque, Nicole, lo dijiste, el 1% va a ser empleados. La gran mayoría va a ser clasificado o independiente o en algunas legislaciones se han creado diferentes categorías. Argentina acaba de adoptar una legislación laboral que creo que no se debería ni llamar laboral directamente. Y los clasifica independientes. Y así vemos cada vez más. Entonces, para nosotros era clave que este convenio incluyera a todos y que diera las mismas protecciones a todos. Dicho esto, nos encontramos en la conferencia el año pasado, fue muy difícil por muchos motivos, más allá de que uno pueda hacer sus propias reflexiones de qué cosas tuvieron que haber mejorado como grupo, ¿no? Y como secretaría en mi caso. Fue muy difícil toda la dinámica, pero así todo se logró que haya una votación para un convenio, se logró una definición amplia y se logró el primer derecho que existe en la OIT al derecho a la información de los algoritmos, que fue también el punto que está marcado y por el cual llegamos a esta discusión, que existe un vacío normativo. ¿Por qué estoy diciendo esto? Porque cuando hablemos de red lines, cuando hablemos de las líneas rojas, hay que también evaluar todo, ¿no? Estamos logrando regular algo que no existe. Eso es muy importante y que aplicaría a todos los trabajadores sin importar la relación de empleo. Segundo punto muy importante. Dicho esto de paso, había 3 puntos que notamos el año pasado que los gobiernos no nos estaban apoyando, con la claridad con la que estaban apoyando otros puntos. Uno de ellos era el tema de salud y seguridad. Consideraban algunos gobiernos, ni cuento el sector empleador, ¿no? Porque ellos no van a apoyar nada. Digo, las plataformas estaban diciendo todo que no. Me refiero a los gobiernos que querían un convenio, pero que así todo nos estaban advirtiendo. Y nos decían, pero miren que no puedo no puedo darle los mismos derechos a un independiente que a alguien que está considerado en relación de empleo en términos de salud y seguridad. Eso para nosotros era tremendo, porque estamos hablando de salud y seguridad, que es un principio de un derecho fundamental. Con lo cual hicimos un trabajo muy fuerte, todos ustedes hicieron un trabajo muy fuerte y logramos que en el informe azul la oficina cambiara y nos asegurara que tenemos un artículo que aplica para todos. No es el artículo más fuerte del mundo, sí, ya lo sé. Pero se puede reforzar. Y es un artículo que va a aplicar a todos y que lo podemos reforzar. Lo podemos reforzar poniendo exactamente los riesgos que se crean por los algoritmos, poniendo exactamente la necesidad de información y de consulta, poniendo exactamente la importancia de abordar los riesgos psicosociales y ergonométricos. Lo podemos reforzar, pero aplica para todos. Eso ya es un gran paso. El segundo punto que notamos de los gobiernos, que muchos de ellos no nos estaban apoyando, es el pago o remuneración. Y Nicole lo explicó muy bien, son 3 artículos. En realidad es un artículo, 3 párrafos. Un artículo dice hay que pagarle en tiempo, básico. O sea, menos mal que nos pagan por trabajar. O sea, básico. Pero lo dice y aplica para todos. Voy a ser honesto. Dice eso. Segundo párrafo, el que podría ser muy interesante, poco más rico, aplica solo para quienes están en una relación de empleo. ¿Es lo que queremos? No. Lo venimos diciendo, no lo queremos. Pero no tenemos hasta ahora el apoyo de la mayoría de los gobiernos. Eso también hay que tenerlo en cuenta. Y el párrafo 3, que no es lo más lindo del mundo, pero ojo, que tampoco hay muchos convenios en la OIT que en términos de pago, porque no lo hay, están dando al menos un lenguaje que permita a los gobiernos tener la obligación de expandir y de proveer medidas en lo posible, lo más cercana a aquellos trabajadores en una relación de empleo, que es el artículo 9.3. No digo que sea perfecto. Lo que digo es, así como está, ¿hay alguna forma que podamos enmendarlo para mejorarlo? Llegado el caso en que no logremos convencer a los gobiernos, y ustedes están en el terreno, yo necesito que ustedes convenzan a los gobiernos. Si no lo podemos convencer, ¿qué hacemos? Porque por otro lado estamos ganando derechos nuevos, que también son muy importantes. Y como les decía, tardamos 10 años en lograr un convenio. Es lo que hay en la OIT, esto es lo que tenemos en la OIT. Entonces, yo lo que quisiera es que tengamos esta valoración. ¿Coincidimos 100% en que debería aplicarse a todos los trabajadores? Sí, rotundo. ¿Y que hay que seguir peleándolo? Sí, pero tengamos un plan B, ¿eh? Porque también es cierto que no estamos viendo a los gobiernos 100% apoyarnos en esta. Y tenemos algunas ideas, así que si ustedes seguramente también tienen muchas ideas, piensen ideas que tengamos y mándenoslo, no la pongamos en online para que no lo sepan los empleadores o las plataformas todavía. Pero digo, compartámoslas, tenemos un mes, compartamos ideas, pasémonos enmiendas. Estoy encantada de hacer eso. Seguridad social, estoy totalmente de acuerdo, claro, hay un claro elemento que diferencia entre que sos un empleado o no. El texto anterior parecía dar más claridad incluso, y ahora dice mismo sistema de seguridad social dependiendo de la relación de empleo que tengas. O sea, la verdad que ojalá que no lo obtengamos. Pero también lo difícil es que del otro lado están las plataformas que no quieren nada, y lo que menos quieren es que tengamos algo vinculado a los algoritmos, y ya lo logramos. Entonces, para ellos eso es algo tremendo y nosotros es un gran avance porque es un derecho nuevo. Pero sí, sigamos peleando por seguridad social. Sigamos peleando, ahí también estoy de acuerdo, y por ahí hay una mirada que podemos tener de diferencia, es que, pero no es porque sea diferencia, sino porque tenemos que seguir el lenguaje de la OIT. Y cuando se habla del lenguaje de la OIT, quizás no es el lenguaje más claro del mundo y uno quisiera tener una definición bien clarita, pero cuando hablamos para ser responsables a los empleadores o a empresas, en la OIT se usa un lenguaje que es el que venimos usando, que es el persona jurídica o natural, ese es el lenguaje que entendemos que encubre a todos. Entonces ahí queremos avanzar en lo que ya está construido y no tener que volver atrás y abrir textos que ya fueron acordados con lo difícil que fueron. Pero también decir que efectivamente hay algo que sí me resuena mucho, que marcó Nicole y que me parece que tiene toda la razón, y es que ella lo marca más, o Nicole lo marcas más con los del sistema de subscription model, ¿no? Que la verdad es que en la OIT, y nosotros venimos hablando de eso ya del 2020, hay un informe de la OIT que ya lo marcaba, y siempre y venimos con esta claridad. Los trabajadores no pueden pagar por trabajar. Tiene que ser un principio básico. Y no es un principio nuevo. Yo los invito, el convenio 181 de las agencias de empleo privada tiene una obligación clara que dice que quienes buscan trabajo no deben pagar por trabajar. No lo vemos así en el convenio de plataformas. Está mal. Y si querramos en algún momento asumir que solamente hubiese aplicado para quienes están en la relación de empleo, que no coincido, pero ¿por qué está esa prohibición de no pagar fees que incluye al modelo de suscripciones? ¿Por qué está en la recomendación y no en el convenio? O sea, esa parte de la oficina estamos totalmente en contra. Y acá necesitamos el apoyo de ustedes. Hagamos mucho esfuerzo para que los gobiernos entiendan que un trabajador que paga por trabajar es inaceptable. Y no solamente porque el hecho es inaceptable en sí, sino también porque tenemos un montón de historias y un montón de datos en donde trabajadores quedan atrapados en situación de trabajo forzoso, porque para pagar para trabajar se meten en deudas también. Entonces, creo que es un espacio donde ahí tenemos que trabajar muchísimo, prohibir el pagar por trabajar. Hay muchos temas más, lo sé, que debemos incluir, pero sí quiero, que sé que queda poco tiempo, agradecerles. Por favor, mándenos las enmiendas. Tenemos un mes. Yo compartí ahí también nuestra campaña. Compartan, la presión tiene que estar, logremos este convenio. No va a ser el mejor, pero va a ser el primero. Y de ahí vamos a desarrollar mucho más tarea en conjunto, porque esto recién empieza. Así que muchísimas gracias a todos ustedes por todo el apoyo y el trabajo.
Thank you so much, Monica. From our end, what we will do is we've gotten so much information from workers on this call already. We will try to collect this and create some sort of document or a seed document for you to work off, and we will send that to you. There are also some amendments that WIGO is working on, and we can send that to you as well. I'm sorry I didn't get to have more questions and comments from others on the call. I know there are so many people who want to weigh in, but thank you, Monica, for responding to some of the things that our speakers have said. We are almost at time, so I want to end the webinar with a few notes. The next step, like I said, is sort of collecting these amendments. Like Monica said, we do have more than a month. So we have time to sort of strategize and work on this together. We also need to orient, again, like what Monica said, to government positions, and the lobbying work needs to happen as well. I also want to flag a meeting in Nairobi, which is happening in May. So some of us will be meeting in person to work through this together. And there will be perhaps something that comes out of that we can share with groups as well. And the final note is that in May, again, right before the ILC, we will try and convene another space. And this is a very specific space because at WIGO, we see a lot of value in connecting the dots. And so there are parallel conversations happening in June, not just on the Platform Work Convention, but there is conversations on gender and conversations on social dialogue. And these conversations are relevant to platform workers too. So we must connect these dots. So in May, we will try and convene a space that tries to hold all of these ideas together. And we will extend the invite to everyone. Folks, please follow the WIGO channels and you will be updated. Everyone will receive a recording of this and any material that the speakers have used. So you will get the PowerPoints, and Monica had a PowerPoint which she didn't share here, but she has sent to us. So we will share that with everyone. And thank you so much, folks, for engaging and holding the space together.
Thank you.
Thank you. Bye.
Muito obrigado.
Saloni.
So wonderful.
Thank you.